Welcome back, everyone. I am Cas Piancey. I'm joined, as usual, by my partner in crime, Mr. Bennett Tomlin. How are you today?
Oh, let's go with okay.
Don't answer.
I'm okay.
Don't answer.
How are you, Cas? I'm here.
We're alive. We're alive and breathing. But I think it's really cool because we're joined by a super special guest today. Corey Frayer was like the senior advisor for crypto oversight for the SEC, and now is working for the Consumer Federation of America as the new director of investor protection. Corey, welcome to CCC. How are you?
Thank you. It's a rough time right now. So not great, but excited about this new job. I'm excited about the chance to, continue the work I've been committed to my career. So there are ups and downs.
And we should just say at the top here, Corey is here in his personal capacity. These are Corey's personal things. They are not the opinions of his employer.
Right.
Correct.
And on that note, it might be easiest if we got started by talking about what your role at the SEC was, and what it looked like, trying to regulate cryptocurrency.
Yeah. So there was obviously a lot going on. And the SEC is a large organization with a lot of different divisions, a lot of different policy areas. So my main jobs were essentially advising on strategy and tactics, and then making sure that all of the disparate parts of the agency were consistent in how we address crypto assets. So on the rulemaking side, making sure we're using the same language there as we did in court filings, just making sure we were sort of unified in that approach. And not in any places where we were addressing crypto, sort of especially creating litigation risk for ourselves, saying things that could be used against us in these, big cases we were developing.
So do you think you could talk a little bit about what the SEC's mandate is and how that affected the strategy the agency took when it came to cryptocurrencies and crypto assets?
Yeah, I think that's one of the big issues that we have a very different mandate. I'm going to keep saying we, even though I'm not there anymore. So the SEC's mandate is very different from like a banking regulator, which has what's called prudential authority, or essentially safety and soundness authority. And they get to look at a product and say, this is bad for the banking system, this is bad for consumers, you're not allowed to do that. The SEC's mandate is one of disclosure. So a thing we would often say inside the agency is, you can do a Ponzi if you disclose it. If you say in your registration, like, we're a Ponzi scheme, you can do illegal things and disclose that in your business plan, and that's it. Like,
we're letting so many bad people know this right now.
You still may violate federal laws.
They know.
You still may violate federal and state laws in the process.
Absolutely. You got fraud. You got yeah. But it's just
But the SEC's goal is to make sure that the investors have all the information they're supposed to have.
That's correct. The mandate is investor protection, fair and orderly markets, capital formation.
Yeah. And so how did that interface with or affect how the agency came up with its cryptocurrency strategy?
So, I mean, it was actually pretty simple because the issue with crypto is the vast majority of these tokens meet the Howey test. They are securities, but they weren't registered. And so they weren't meeting that basic disclosure requirement. That's kind of step one, is addressing the fact that they are securities. They do have an obligation to register and disclose, and they weren't doing that. So that's like a pretty straightforward step one. And even, to their credit, Clayton's administration before us took on a lot of those kinds of cases. Obviously we took on a little bit different strategy, which hopefully we'll talk about later. But the first barrier to everything was demonstrating that these were investment contracts, securities.
Okay, and for our audience's benefit, we've talked about it a couple times on here before, but could you tell them what the Howey test is and how that relates to these being securities?
Absolutely. So there's actually a big misconception about what we were saying about crypto assets, which is that the crypto asset itself was a security. And what we allege is that the crypto asset is part of a scheme that makes it a security. So the concept of an investment contract is a longstanding concept from the blue sky laws. And the reason it was included in the act, and the reason the Supreme Court decision, the Howey decision, came down, was because Congress was aware when they passed the law that people would try to evade it. And so the investment contract test is a purely economic analysis. And it says, basically, no matter what you call yourself, if you are economically the same as a security, you're a security. And so that test is an investment of money in a common enterprise with the expectation of profits based on the efforts of others. And quite frankly, like many securities meet that test, regardless of whether they're enumerated in the 33 and 34 Act. But the Howey test was really meant to sort of capture the evasion and all the ways that securities could be introduced into the market as sort of something by any other name.
Was the SEC's goal to get these cryptocurrencies to come in and try to find a way to register these things as securities? Because the refrain we've heard from the cryptocurrency industry over the last several years is that their tokens were incompatible with existing registration documents.
So yeah, getting them to come in and register was certainly the beginning of the strategy under Clayton's term. A thing that kind of morphed there is that under Clayton's term, most of them were calling themselves ICOs, or initial coin offerings. And so when you walk out into the world and you say, we're an ICO, it's very hard to go in front of a judge having named yourself after sort of like the most famous layperson understanding of securities and equities and be like, well, we didn't really know this was a security. It's kind of like an absurd argument to try and make. So those cases were, pretty easy. And I think that there was a conception at the time that market wasn't really going to get a foothold and expand in the way that it did. So yeah, I think that's sort of, that was like sort of the first step.
Well, I guess part of the refrain Cas and I have heard from the crypto industry is that these things can't be registered. The types of questions asked in these forums are fundamentally incompatible with the types of things these issuers are doing.
To tag on to the back of that really quick, they also were saying a lot, and we're still hearing this from like Coinbase and, major operators in the cryptocurrency industry, that like, even if they did go in there and try to work with the SEC on stuff, that ultimately they would just get bogged down in a mess and told off by the SEC or charged with something, or, that regardless of how they were trying to play nice, the SEC would come after them no matter what.
In my experience at the time, while I was there, absolutely untrue. No one has ever demonstrated to me what is fundamentally incompatible about a crypto asset and the current set of securities regulations. We went in there very open to hearing that argument and being given detail around that. And we spoke both to crypto asset issuers and crypto asset platforms and traditional platforms that were thinking about getting into the crypto asset business. And none of them could demonstrate for us what the technological issue was that made them unable to register and operate like any other securities market. The argument essentially boiled down to, we set up these platforms with these huge conflicts of interest. If you make us look like the traditional securities markets, this business is not going to be economical. So essentially, by making us follow the law, you're going to shut us down. I think that was like really what was going on. And I also think that has to be taken in the context, like whether those were good faith or bad faith arguments. The initial idea behind crypto is this is going to be something that's not subject to government regulation. Like no matter how you look at this, the underlying ethos is that they didn't think our regulation was ever going to be legitimate.
The original intent of Bitcoin was to undermine the existing banking system. It wasn't to necessarily like destroy the banking system. It wasn't to ruin governments or anything like it. It was just to have a completely different and unregulated form of money, right? And I guess this comes to the question of like, at what point does the SEC feel like a asset like Bitcoin or Ethereum or Ripple, at what point are they, quote, sufficiently decentralized and they are no longer a security? I
don't think decentralization, other than the concepts of, for example, a common enterprise, right? And sort of the organized efforts of others. I don't think decentralization was ever sort of the right way to look at economic analysis. And like very unfortunately, before we got there, a former director of corporation finance, which is sort of like they are the experts on what is and is not a security, that's their lane, said a lot of things about crypto in its nascent state that create a lot of problems for the agency. And I think one thing, getting into the constraints the agency has is that the courts don't look at the SEC as like a thing that changes administration to administration. The court looks at the SEC like a 90-year project that is supposed to be consistent with itself. So we're held accountable to things that have happened before us. So like those statements carried on and were used to challenge Ripple as we continue to litigate it. That was an enormous challenge for us. And the other thing is like the fact that this market was allowed to grow so large was a big challenge, because you got to go in front of court and explain, like, if this was so illegal, if this was obviously securities, why didn't the SEC do anything about it? Why'd you let it get so big before telling him this was an illegal business?
Well, and during that era, you had interesting messages coming out of the SEC with like Clayton saying basically every ICO I've seen is obviously a security. And then Hinman going, I don't know, some of these seem like they're sufficiently decentralized and aren't securities anymore. Plus, you had the Dow report coming out in that era, which was like, this is very clearly a security, and things that look like this are also securities. And so there was a bit of difficulty in getting everyone unified in the same message during that period, which seems to have had costs going forward for years to come.
I would just add, you are absolutely correct that I think prior to us, things had been pretty inconsistent. And I would add one other thing that is not well known, which is that there were a couple of tokens that were issued. They were not registered, but they were issued legitimately in an exemption to the registration. So there's a handful of
like
exemptions
Stacks.
to registration. Yeah, exactly. Stacks, Maple, where they were trading on exchanges. And the moment you're a platform that facilitates trading of a security, you're a securities exchange. And even though those securities were on platforms that meet the definition of exchange, prior administration didn't go after those exchanges. So that was another sort of inconsistency in interpretation of the law that was challenged.
Yeah, well, and I think even since then, one of the Stacks like founders has come out and said they regretted using that exemption because it made it harder for them to convince some cryptocurrency exchanges to list them, because they were worried it would end up drawing SEC attention to them.
That was an enormous hurdle to actually getting someone to come in and register. And I'm sure you guys have heard Gary a million times say, hey, just talk to us, just come in and register. And even people who wanted to come in and legitimately work with us, and we met with a lot of people. We met with anyone who would come talk to us. An issue that we also, like an economic issue you couldn't get around, was that if you became a legitimate exchange, it was really hard to find a token that was willing to register and join your exchange. And the tokens didn't want to register because there was no exchange for them to trade on once they were registered. So you had this like chicken and egg problem of trying to get both sides of this market to come together and have one legitimate exchange and registration process.
Yeah, which results in like people like Prometheum declaring other tokens securities without those tokens agreeing to register or do anything to try to solve that chicken and egg problem. Is there any additional context you can give it to us here on like what seemed to be one of the biggest cryptocurrency cases that like the Clayton SEC brought that ended up being continued on, the Ripple case, and like what the strategy and thoughts were behind that one?
And quickly, just to jump in here, like if you can, I think Bennett and I have like hardly ever talked about the Ripple case at all. I think
Ripple's so pointless.
Well, not only because it's pointless, I actually think we largely felt like once you guys went after them, we were like, okay, well, this is a slam dunk. Like, I think we genuinely thought that it was like, okay, well, this is over. We don't really even need to talk about Ripple anymore. This is done. And then years later, it just feels like we really lost the plot on that one. So if you can help our audience and us understand it a little better.
I will start with the most controversial thing I'm going to say about this, which is like, despite the press and despite what crypto said about it, Ripple was a win for the SEC. It established that at the very least, those first contracts that went out were in fact securities. The second part of that decision, of the Torres decision, was a pretty wild interpretation of the securities laws that took this crazy argument about investment contract and gave it a life that it shouldn't have had. The investment contract concept can't be split up into the idea of an investment and the idea of a contract. It's like, the point isn't literally about a contract. It's like saying a skyscraper isn't a building because it's not in the sky and it doesn't scrape anything. The fundamental thing you're representing there is a broader concept. And what crypto was arguing is that you needed privity because it's a contract. You needed a direct relationship between the issuer and the buyer in order for it to be an actual contract. It would be like saying in an IPO, the first buyer of a share, it's a security. But once it trades on the secondary market, the securities laws don't apply anymore. So it's a wild interpretation of the law. And shortly after it was issued, Jed Rakoff, who is seen as like the dean of securities law on SD and the Southern District of New York, where that case was decided, and the district that Torres is in, ruled in Terraform on a lot of similar issues that they were obviously securities. And it was the way that was phrased and some of the things that he said after that made it very clear that he thought the Torres interpretation was really wild. And so one of those issues is that like we have a very different court system. A lot of judges have been appointed, and like this was an Obama appointee, but a lot of judges have been appointed that have upset the traditional interpretation of the securities laws, and that's been an enormous challenge as well.
Sorry, and just to like backtrack even a little bit more, what exactly is Ripple and what is XRP, and what was their goal? Why were they coming to you guys? Like why were you guys going after them?
Yeah, so I mean, I'll start by saying that if I were in the position at the time, I'm not sure Ripple is the case I would have chosen. That said, they did pretty straightforwardly raise capital. They asked people to invest money in them creating an ecosystem that essentially was first and foremost going to be sort of like an intrabank payment system. And then like eventually, I guess, a world currency and payment system. So yeah, that was the pitch. But it's like really clear that if you're going to take someone's money to build a project, they're relying on you and your expertise, and you're pooling a bunch of people's money to build that project. You're squarely within the securities laws. Now, we ended up running headlong into, for example, the Hinman statement. And there was a huge fight over not just the statement itself, but getting sort of all of the staff comments. And the way staff comments work on those issues is like, you pressure test that stuff. There's a lot of things in those documents that the SEC didn't necessarily believe, but staff raised as, you should think about this, you should think about this. And that was a costly set of facts in that case.
And if I remember right, the Hinman statement was supposed to be a statement in his personal capacity at some event too. Like it wasn't a vetted SEC speech, if I remember right, but it got covered and then he's still in his role. And so they attributed the statement to him.
Yeah. Sort of one of the fundamental truths about financial regulation generally is it's a one-way ratchet. It's really easy to deregulate, and it's really hard to regain ground. You can deregulate by just not doing something. You can deregulate by having someone who's in a position of power, even if they're just staff at the SEC, sending a message to markets that this stuff is legitimate. Look, I don't agree with it, and I don't think someone, one staffer who is not appointed or confirmed by the Senate should be able to make proclamations that have effect in the marketplace. But it is a somewhat convincing argument to a judge to say, hey, this guy who is in charge of this division at the SEC said it was fine. Like, what give?
I'm curious. We briefly touched on it before. I feel like you like you said, you guys are dealing with 90, almost 100 years of history here, where you are expected to be consistent in the structure of how you regulate these markets. I'm curious how political the SEC is now. Maybe even before. I think it's clear that now there is no, it is the same as politics, and clearly they've decided to do whatever they want with it. I would also be curious what your relationship was like in terms of the regulation of crypto for you personally with, I don't even know how to say her name, but Hester Peirce. I don't know how to say her last name. Peirce, yeah. Hester Peirce, yeah.
It's a really good question. I think everybody in the independent agencies does genuinely try to operate without political influence, generally tries to recognize that we all have a bias and try to be consistent and fair in our decision making. I would also say that there is nothing in our democracy that is not political. It's just fundamentally true of economics and political economy is that everything is in fact political. The person who's in charge of the SEC is chosen by the president. That is a political position. So certainly there are politics involved. In terms of the efficacy of political pressure, I don't think, at least in our administration, we were ever driven by political consequences or political pressure. Like the closest you could characterize us as getting that is sort of like trying to demonstrate reasonableness in response to the fact that although judges are, supposed to be fair interpreters of the law, there is inherently a political angle to that. And just everybody's human. And so we did, I think, sort of try to speak to some of those things and demonstrate reasonableness because you kind of have to contend with that political issue. Certainly the amount of criticism we got from Congress and a lot of the beatings we got were because crypto had become a pretty powerful political entity at that point. So I think the courts really had a lot more impact on what we were trying to do and what we did, and sort of trying to navigate around that extremely challenging judiciary environment we were in than any kind of political influence.
One of the most interesting political things I observed before was the politicians who wrote an angry letter because members of the SEC were meeting with members of FTX and FTX US. And then a few weeks later, after FTX declared bankruptcy, they wrote another letter to the SEC asking why the SEC hadn't taken more aggressive steps on FTX. Speaking of FTX, that kind of political things, do you have any thoughts on how all of that went down leading up to the collapse, after the collapse, the interaction between the politics and the regulation there?
Yeah, the first thing I want to say about that is, again, just one of those fundamental truths about financial regulation, which is you don't get credit for the things you prevent, and you always get blamed for the things that you didn't. And I think that's really well reflected in this, the political position of at first being how dare you regulate this? And then being well, how on earth did you miss this? And that's just sort of part of being in that space. Another thing that I think I would want to give us lots of credit for, because the FTX thing wasn't a total surprise. I'm not going to say we sort of knew the ins and outs of what was going on inside that business, and there are a lot of reasons for that. The hook to U.S. oversight at FTX came fairly late in their development as far as FTX US was concerned. They initially only offered a handful of things that were really hard to argue were securities: Bitcoin, Bitcoin Cash, Litecoin, a stablecoin or two. And
I always forget about Litecoin until someone mentions it.
Fair. And it was only in 2022 that they introduced the no-fee stock trading. And that's when we really had a hook into that. But that's pretty late in the game for where they ended up.
I also, tell me if I'm wrong, but it seems like regulators essentially did a pretty good job, because what ended up happening is FTX International did all the fraud. And as far as from what I've heard, there was very little crime happening at FTX US.
Probably some.
I said very little. I said very little. I didn't say none.
They had at least most of the money most of the time, which is vastly different than FTX International.
Exactly. I think my point being that you guys, along with other regulators, kind of are told oh, look at what FTX happened, and that was an American company, and it's well,
yeah, where were the Bahamian securities regulators?
Yeah, exactly. I don't know how you guys can stop fraud all over the world. I that seems like a tough ask,
Yeah, and I put that on my list of constraints. Is there's a ruling called Morrison, which really narrowed down SEC's authority to deal with foreign securities that make it into the U.S. market, and so the foreignness of FTC was also a challenge. I'm sorry, FTX. I would say that you probably don't want to separate the parent company from a subsidiary in terms of crimes and fraud. But more than anything, it was that inability to look into the U.S. entity until fairly late in the game that I think was the more driving factor of just not knowing what was going on in there until, it's too late. And one other thing I want to say about that is, again, there's a conception that the fragility of the crypto market sort of caught us off guard, and we weren't doing anything beforehand. And one thing I'll say is that it takes a long time to develop cases. As soon as we walked in the door, we decided we were going to take a different strategy than Clayton. Instead of playing whack-a-mole with all these securities, we're going to hit them in the notes. We're going to hit them at the intermediaries, at the exchanges, where the stuff was collecting, because you have a bigger impact on that. The other thing I want to say is that there was an accounting interpretation we did called SAB 121. It's extremely unpopular, But in April of 2022, working with our accountants, we had identified that the custody arrangements and the safeguarding around crypto were actually really unpredictable in terms of established bankruptcy law, state treatment under the Uniform Commercial Code. We identified that was an issue. We thought it was bad for investors that investors in crypto companies, that they would not be aware of the potential liability of that company to its customers. And so we said, look, you've got to disclose this liability you may have in the case of bankruptcy or in the case of, being resolved by the FDIC, something of that nature. It's an example of good financial regulation begets good financial regulation. So what ended up happening is banks, which are also public companies, also had to follow that gap interpretation. And the banking regulators didn't. I mean, they have their own accounting that is called regulatory accounting instead of GAAP. And they decided not to change that accounting. And ultimately, banks would have had to raise more capital in order to justify having those assets on their balance sheet. And so we sort of fundamentally kept the traditional markets separate from the crypto markets before that crash happened. And that was a really big deal in terms of contagion into our markets. And I think you look at the 2023 regional banking crisis, and 3 of those banks were heavily involved in crypto. We bailed out like $3.3 billion of USDC reserves. Signature was a huge player in the crypto space.
You've walked right into my trap. I wanted to ask you about about stablecoins. So you're
Sure.
bringing up stablecoins, and I think for Bennett and I, it has probably been the number one most important systemic risk for cryptocurrency and for the globe.
I wish I knew less about stablecoins.
Yeah, me too. So I guess
I wish I knew less about crypto.
Sorry to have you on, Corey. But I think our forte at this point is stablecoins, and I am curious why. Maybe I'm wrong again, but I think the only stablecoin you guys have really gone after was Lunaterra. Is that right? Is the kind of the feeling that the stablecoin market just is not something you guys are supposed to be regulating? Is this a market for different regulators? Is it I guess I'm just curious why that's the only stablecoin you guys have gone after.
Yeah. In terms of the question you just asked, in terms of whose job it is, the unsatisfying answer is it depends. As we talked about earlier, one of the prongs of the Howey test is an expectation of profit. So if you're getting a stable coin, it's hard to argue that you're expecting that to rise in value when the pitch is this is going to stay at this price. Now that doesn't mean there can't be arrangements that do make a stable coin a security. And what happened in the Terraform case with Terra Luna is that they had created a secondary market and the Anchor protocol where they were saying, okay, like you get this, and then if you deposit it with us, you're going to make a profit of the interest rate you get in this account. So there you have a promoter saying, essentially, you're going to make a profit off of this in a way where, at the very least, I'm not going to say none of the other ones are securities, but it takes a lot more work and it takes a lot more fact finding to try and demonstrate that there is a profit motive or a promise of profits as part of that arrangement. Not impossible, but pretty hard.
I mean, like, I just, like, off the top of my head, I'm like, oh yeah, remember that time that Tether had all their problems and started their Unis Sed Leo token, where they basically promised, like, we're going to give you a return on your money and more cash and interest at the end of it. And it's like, that's Tether related, that's Bitfinex related. But I guess you're saying, like, just the complexity of it and them not being based in the United States and them saying they don't serve U.S. customers, like, does that just throw a wrench in all of that?
Yeah, I mean, there are lots of challenges. And again, this gets back to some of the other fundamental constraints of the SEC. We had to apply our resources very, very carefully. So the SEC has 4,800 employees. We have a budget of $2 billion that is appropriated by Congress. They set our budget, even though we get all that money back by charging our registrants. And we have 1,400 enforcement attorneys. We oversee a $125 trillion market. To sort of give that a comparison, there are 3 banking regulators, the Fed, the FDIC, and the OCC. The Fed has 25,000 employees. 1,500 of those are bank examiners. The FDIC has about 6,300 employees. The OCC has like 3,500.
Oh, wow.
They oversee a $24 trillion market.
You are
and
so
in addition to
short-staffed.
that, like we're super resource constrained.
Oh my God.
And then when you think about the places where they need to focus their energy, JPMC alone is a sixth of the assets in the banking space. The top 6 GSIBs are right around like 55% of the market. So you have a like pretty concentrated place where you can direct your energy. And that'll also say that even though that's the banking regulator's issue, most of those banks have a very large broker-dealer, which again comes back to the SEC to regulate. The appropriation process, even though we're budget neutral, makes it really hard to plan in advance to try and recruit. If you hire too many staff and then you get a budget cut, it's like, well, where are we going to find the money to run Edgar? You know, how are we going to keep our computer systems running? So like that's one of the constraints. And I would say with regard to the constraints and to folks who think like we didn't really put enough energy towards crypto, our cybersecurity and crypto unit, we doubled that to 50 attorneys. That is 3.5% of our enforcement staff. The crypto market was under us sort of at its biggest before the very end of our term, maybe like a $2 trillion market, more than half of which is Bitcoin, which had already been decided as, you know, not a security. So you're talking about 1% of the market where we're deploying 3.5% of our enforcement folks. And also like those things tended to go into litigation. And as you go into litigation, that team is now committed to showing up in court, filing briefings. Like they're doing, it's harder to get them to do investigations because they have a lot on their plate in terms of going to the court. And the last thing I'll say about that is when you bring a case like that, there's no sort of like one person who knows all of the securities law. It's too much. And so they work with our rulemaking divisions to sort of make sure they're really tightening up those arguments. So not only is there limited enforcement staff, but those enforcements are taking up rulemaking time in which you're trying to, you know, get a handle on the rest of the traditional markets. And it also leaves, you know, there are lots of places in traditional markets where probably we would have liked to bring more enforcement actions in that very large space where people hadn't signed up for, you know, the volatility of the crypto markets and just expect the regular securities laws to protect them perfectly. And you just have to make these really tough decisions about where you deploy those resources.
A couple of times here you've referenced like the fundamental constraints of the SEC. Can you talk a little bit about what those fundamental constraints are and how that kind of affects what investigations get started and what investigations become enforcement actions?
The first and foremost is the limited resources overseeing such a huge market, and also the limited authority in terms of sort of what we can do proactively. Again, if you're a banking regulator, you can say, you know, it's sort of what we called a merit regulator. We sort of had to take the position that we don't get to make a judgment about the business you're doing. Our judgment is purely about the disclosure. And then obviously, you know, fraud. So like that is having to establish that and then being resource constrained are two of the biggest issues. In addition to that, unlike prior securities issues, crypto is able to just print itself limitlessly. So you have like having 15,000 nationally available non-compliant securities is not something that has happened in the past. So getting a handle around that is enormous. There's also procedural constraints. The commission itself can slow down enforcement actions by, once they get to the formal order stage, requesting a vote on every subpoena. And you can only get the commission together so many times to vote in a month. And that can, you know, slow those investigations in such a way that it's like pretty frustrating for the enforcement staff. And also just, you have to go to court to fight those things. You have to get all of your depositions and fact seeking in line. You have to do all this discovery. Like slowing that process down is a huge, huge drain on resources. The other thing is every one of our cases fundamentally starts with proving that there's a security involved. Even if we go after a large platform, we have to demonstrate every time that there's a security here. And so making sure we found cases where that was at least mostly a slam dunk issue was a really important, and where we wanted to take on cases where that wasn't the facts, that can be pretty tough. And then again, inheriting the past positions of the SEC, really big problem, a really big constraint. And there's also an issue with the CFTC, where then when they would establish futures markets in a particular crypto asset, the challenge to us becomes, like, we still are ultimately the arbiter of what is and is not a security. That's clearly the SEC's job. But going to a judge and trying to explain why two federal regulators fundamentally disagree about the status of a particular asset, huge challenge. It's not a good look. So yeah, there are more constraints, but I think those are kind of the highlight.
Well, and one you raised there feels very relevant right now, which is that it's possible for the commissioners to raise the additional barriers and in so doing slow down a lot of this action. And there was some reporting recently that now lower level staff are not even going to be able to open investigations without approval of the commissioners. That came from Reuters. So it seems, based on what you said, that is going to be a massive barrier for investigations and enforcement going forward.
That's one of the things that I would describe as genuinely kind of political interference, coupled with another, really terrible developments that have happened at the agency with the new leadership. But yeah, to that end, obviously the chair would come in and establish some enforcement priorities. And if we saw something that looked especially bad, we would say to enforcement staff, hey, you need to devote some resources to looking at this. That said, most enforcement attorneys have access, they all have access to what are called TCRs, tips, complaints, and referrals. That's a reform we put in post-Madoff to make sure there was a centralized repository of that kind of incoming information. So it wasn't just like one staffer. If they didn't do a good job chasing something down, no one else would have insight into that kind of complaint. We had about 45,000 of those a year. So typically what an enforcement attorney would do would sort of be looking at the market, looking at the news, looking at those TCRs, and individually deciding, here's what I'm going to start an informal investigation on. And then they had to have the ability, with the cooperation of the head of the Division of Enforcement, to do a formal order where you can actually start issuing subpoenas, taking depositions, really get enforceable powers to collect facts. And then only after you had done that would you present the facts to the commission for the ability to bring that complaint into the courts. And this change now where essentially you can't really spend resources on an informal part of the investigation. You got to ask yourself, how are they going to go out and identify the problems in the marketplace? And then what is the amount of time the commissioners are willing to spend to authorize these? I mean, if they wanted to do that at all, to authorize these investigations that 1,400 individual attorneys used to sort of suss out for themselves. The other horrible politicization that is going on is, and I can't express enough how amazing career civil servants are. And it's getting a little bit of attention right now because we're seeing the interference, but they're typically thought of as sort of lazy, bureaucratic, couldn't compete in the private markets, so they end up here. The SEC staff are some of the most expert and amazing people I've ever worked with. Almost every one of them could go to Wall Street and triple or quadruple their salary.
They often
and they sit
do.
There. Fair enough, but a lot don't.
Okay.
But fair enough. But a lot of them do that job purely out of a belief in justice, a belief in the SEC's mandate, and the job is really apolitical. I wouldn't have want to come into that building and had a bunch of staff being like, we disagree with where you're going with this, so we're not going to execute your decisions. When you go in there, Congress has said, you get to be in charge of this agency, you get to direct where it's going within the bounds of the law. And the staff's job is to execute the instructions they're given. And I'm certain they did that with Clayton before us. We changed a lot of direction we were going in. They faithfully changed direction when we asked them to, and they would have done the same for the new leadership. So going after people for taking on unpopular things with leadership is going to have an enormous impact going forward on the efficacy of these agencies.
We've kind of gone over a lot of the mandate of the SEC and how you are constrained by that. But I do want to talk about something else, which is how close do you guys work with the Department of Justice and other other agencies, the FBI, whoever might be involved, like ATF. I don't know which branches of the government you guys are working with on a daily basis. But I think it's important for people to understand that, like, I know we've kind of stated this already, but like, you guys can't do criminal charges against these people. Like, you are a civil agency. These are civil charges that you are bringing against these folks. So like, for instance, when Bernie Madoff finally got taken down, you guys didn't throw him in jail. The DOJ convicted him of 11 felonies. Like, it has nothing to do with you guys, but like, it does have a lot to do with you guys still, right? Because you guys are talking to them. You are passing this information along. I'm curious if there's times where you've handed them, a booklet about a cryptocurrency or something, like, well, here's some obvious criminality happening, and then just nothing happens, or the opposite, like times where you've handed them something and then immediately they do something about it.
So you're absolutely right. The SEC is a purely civil enforcer, but they do a lot of work with DOJ. When you're going through these investigations, you're uncovering facts that look like they may be criminal. Absolutely. You refer that to the DOJ. You ask them to investigate. I couldn't tell you what the percentage of DOJ moving forward or not moving forward is. I would say that with those attorneys and like state AGs in general, the rest, what we call the resting foot, right? The sort of natural response is, I would like to take on big cases. I would like to raise my profile. So my general sense would be that when we worked with the crims is that good cases generally moved forward. I don't have like a particular insight or number into anything that didn't happen or did happen. And even if I did, I couldn't talk about cases that, never came to the public space. But I think generally speaking, that was a really good relationship.
A little bit unrelated, but you talked a bit about the CFTC regulating futures markets and how that sometimes put the SEC in a challenging position. One of the cases I saw over this last administration where that seemed to come up was on the approval of the ETFs and exchange-traded products, where eventually the issuers were able to point towards these regulated markets of size, these futures markets, and use that to convince the SEC it was no longer worth fighting the approval of those ETFs. Is there any additional insight or color on that years-long ETF dispute that you can provide us with?
The first thing I would say is that under Clayton, that's called a 19B4 rule change, which is essentially an exchange comes in and says, we would like to list this product. And there's an evaluation under the securities laws wherein the exchange is responsible for monitoring and preventing fraud in their marketplace. And so what the staff had to do there was to figure out a way that these futures products, the 33 Act products, the commodity pool products, could be compatible with the securities laws. And what ended up happening was called the Winklevoss test. And that was you needed to have a surveillance sharing agreement with a market of significant size.
Right.
And what essentially that means is there needs to be an agreement with you and in a large marketplace in the future space where if the underlying market was being manipulated, you would see that in the future space. And that would give you sort of the information you needed to track whether or not there was fraud happening. And therefore, you could demonstrate your ability to monitor and prevent that kind of manipulation.
And so, sorry, just to interject quick, did the Winklevoss test come after the settlement with Gemini, where two related party billionaires were like manipulating one of their markets by wash trading or something?
I believe it came after the disapproval of an application to list an ETP that initially came from Gemini. Again, that fights kind of started before we got there, and we got handed it. I will say this. We litigated that case. When they sued us, we could have just thrown up our hands and been like, this is too hard to do. We'll just approve it and move on. We litigated that case. And the courts came down with a decision that was fundamentally about economic analysis that they just got wrong. And sort of the facts against us were really challenging because at the SEC, you distinguish between an ETF and an ETP, an exchange-traded fund and exchange-traded product. The ETF process is essentially automatic because of a rule called 6C11 that got installed, again, years before we were there. And essentially, if you put together a 40 Act product, which is an investment company act, it is, mostly the underlying product is securities. So you'd have these, to get a futures product together, you have to have a bunch of treasuries and other securities in that product. And so they came in under the 6C11, the ETF rule. And there's not a way to kind of stop that without meeting an extremely high bar. So you have these futures products coming into the market. And then when you try to prevent the ETP products, it's like, well, you have these like fairly similar things that are already 40 Act products, like demonstrate why you can't have a 33 Act product. Now, there are reasons they're distinct from each other. There are different economics. There are lots of good fights, but judges are not typically experts in economics. And once you get a bad decision, the question is like, how many more resources do I want to dump into fighting this and appealing this versus taking the L and moving on and trying to go after things you might win.
Yeah, and especially I think that comes in here when you look at it from a consumer investor protection standpoint, and the investors in the 40 Act product are already paying the contango because they're futures based. And so you can construct an argument that the spot based ones would end up being better for the investors.
And they absolutely did.
Yeah.
This also, for me, this brings up a broader kind of vaguer aspect of something that I would be interested in discussing a bit. I don't know how to phrase this properly, but I guess my question for you is we talked about this with Tuffy a bit. The cases oftentimes that you guys were able to settle and I guess essentially win seem to be these kind of smaller scale frauds or abuses. For instance, Soldier Boy or the Stoner Cats one, right? Where these weren't like multi-billion-dollar frauds. These were like Soldier Boy. I don't even know how many securities violations Soldier Boy has probably done in his lifetime. It's got to be upwards of 10. One, it kind of, I think, and this is coming from, I feel like both sides of the cryptocurrency sphere, where you've got the supporters and you've got the people who hate it. And both of them are kind of like, okay, we want to clean up the industry. And on one side, it's like, that means get rid of everything. And on the other side, that means there's obvious bad actors who need to be dealt with, right? There's people like Justin Sun, who I think nobody in cryptocurrency trusts that man. Like they genuinely don't like him. Or Tether, who for years kind of lied and abused their way to being the number one stablecoin forever. And the question is is it just too resource intensive to go after those larger scale frauds? Or is it that the case isn't a slam dunk? Or is it that what is keeping you guys okay, let's just go after Soldier Boy and just get him to plead guilty?
So I think I would want to talk about sort of three types of cases that I think I've heard either you or guests sort of put in that bucket of small fry cases. So first of all, you've got touting, right? Which is a celebrity that doesn't disclose their conflicts of interest and essentially tries to sell a crypto asset into the market. And that is important because you don't want that to proliferate. You don't want celebrities bringing people into the marketplace. And it's also one of those things where you're always trying to, through your cases, move the market, not just win one, but tell people, look, don't do this because we'll come for you. And so those are cases where it was helpful to keep people from getting sort of tricked into this volatile and non-compliant space. And generally, yes, requires fewer resources than taking on a big exchange case, but still important to do. The Stoner Cats wasn't just about touting, but also demonstrating that NFTs could be securities. So it's a precedent-setting reason to go after that. And again, it tells the marketplace, watch yourself. These can be issued as securities and need to be careful. And the last thing I would say is, early on, we went after BlockFi, one of the lenders, which is sort of seen as smaller. That was part of our strategy, first of all, to hit the intermediaries and focus on where this activity was happening. Second of all, that was a really good case for us because we didn't have to demonstrate anything about the underlying crypto assets. That arrangement is a pretty bog standard arrangement called a note, lending them out and then paying an interest rate on that account. It doesn't matter what the asset inside the account is. You have created a note. It's an easy case to win. And that was another place where people are being lured into the market by saying, like, why keep your cash in a bank when you can put it in this account and get like 86% returns?
It might even falsely claim on its website it's FDIC insured if you're talking about Voyager.
Right? Yeah. It's like that was a channel where we were concerned it would bring lots of people into a dangerous marketplace, where there's like a very good argument for us with regard to the securities laws, and also where a whole lot of leverage was being created. Like when you lend out those assets and then use other crypto assets as collateral and run that up the chain, everybody down the chain owes each other. And as soon as the top guy can't pay his obligation, everything underneath him collapses. I mean, like that's what you saw in Crypto Winter.
Suzu and
that's
Kyle
like
Davies.
Yeah, that's like a standard financial regulation thing. And so the leverage, the sort of slam dunk nature of the case, and that it aligned with our intermediary idea was why we went there.
BlockFi is one that I forget. Like that, I wish you guys had. Yeah, like that is a great case. That's a great example, and it is one that I forgot.
We changed the market. We famously got in a spat with Brian Armstrong when we told him, hey, like, you're creating a securities arrangement, and Coinbase didn't offer their lend product. Right. So like imagine a world in which all of that stuff had been allowed to happen. Right. Coinbase being one of the biggest and most influential in the market. That would have made the crisis a lot worse.
Yeah, for sure. No, I agree with you on that. I think so. Here, again, you've entered into a realm that I can push back on. So
sure.
So Stoner Cats, you said like essentially set precedent that NFTs can be securities, considering that our, I don't know if you want to even call him the president, the guy who works for Elon Musk, has done an NFT, a whole NFT product, and has also done his own coin now. In your personal opinion, one, are either of those possibly securities? And two, is it over like in terms of, now if the president is doing it, like you might have set that precedent with Stoner Cats, but c'est la fucking vie, you know what I mean?
Absolutely. Again, failing to regulate is a deregulatory action that is really hard to overcome in the future. So yes, absolutely. With regard to meme coins, and I'm not saying it's a meme coin. I'm just sort of like laying out this category. For the Howey test, have to identify a promoter who said, you're going to get a profit off of this. So like, if you look at Dogecoin, I'm not saying it's impossible to make the argument it's a security, but the guy who issued it said, this is a joke, don't invest in it. It's like, please don't. And so it is hard to make the case that a reasonable investor would have expected profits from a token that was put out as a joke. So like the meme coin thing can be a little bit challenging. It doesn't mean it's not. And sort of, if I were going to try, and I should say, and I should have said at the beginning of this, I'm not a lawyer. But if I were going to try and create the colorable case around the Trump coin, it would be, look, he's got this whole, like he's got the Truth Social thing. He has all of these business interests that are profit making. A reasonable investor might believe that sort of becoming part of that ecosystem by buying into the Trump meme coin suggests the ability to get profit from like that larger ecosystem of things that the Trump businesses are doing. Not a slam dunk case. I think that would probably be pretty novel. But like, if you're trying to establish precedent, it's not exactly the thing I would first go after. I think the other thing that's really scary about this is that to the extent that these would be securities or regulated by another regulator, like this is a guy who has the power to choose who's in charge. And you're going to be gutting the laws that you may have broken potentially, and also gutting the enforcement arm that would have been able to hold you accountable. So it's a very scary thing to have a president with these conflicting business interests.
You talked about how if you basically say like it's a Ponzi scheme, then the SEC might be hamstrung. It doesn't mean that,
to be clear, a little bit of an exaggeration and hyperbole, but
sure,
I think it
sure.
demonstrates, yeah.
But I guess I'm on the gettrumpmemes.com website right now. And it says, Trump memes are intended to function as an expression of support for and engagement with the ideals and beliefs embodied by the symbol $Trump and the associated artwork, and are not intended to be or to be subject of an investment opportunity, investment contract, or security of any type. So I guess
as long as you put those words on the page, I guess you're safe.
I guess like you said, there you have it.
Saying it's not a security doesn't save you. Just
not financially.
Some people who have lost cases tried that tactic. I've covered some of those cases. Kind of on the topic of future regulation, Tim Scott and French Hill and Bozeman and Thompson all are very confident that they can get basically Fit 21 2.0 passed, signed out of both the House and the Senate within 100 days. I think they're wrong. I don't think they have the majorities, and I don't think they're going to get as many Democrat defectors as they thought a week ago. But Fit 21 largely punts a lot of cryptocurrency regulation to the CFTC and includes a very broad definition of decentralized in order to do that. Ignoring the rest of the context right now and looking just at that piece of legislation, we can get to the rest of the context immediately after that. That bill alone, what do you think of punting such a large portion of crypto regulation to the CFTC?
Yeah. So like I said, I did 15 years in Congress before coming to the SEC. The legislative process is hard. And so a couple observations about that legislation and legislation in general is that, first and foremost, it was easy to unite the crypto industry against the demon of Gary Gensler and what we were doing. It is much harder to unite an industry around the particulars of a bill. There are a lot of competing interests. There are a lot of people who like one thing and not another thing, or are maxis in one space, that will make that hard to construct something that they actually want and actually has, the possibility of passing. So that's sort of like issue number one. The second thing is that the We Want legislation gambit was not about actually wanting the CFTC to regulate. It was about, we don't want the SEC to regulate us. When you're going to be in a situation where the SEC is not serious about enforcing its territory, ideally what you want is to not have the CFTC or any other federal regulator looking at you at all. So that, because that was a dodge in the first place, I don't think they're going to be nearly as excited about pushing members to get legislation across the line, because they don't need protection from the SEC anymore.
Yeah.
And the last thing, you already kind of mentioned this, if you get the definition of blockchain or crypto asset or wherever you want, if you get that wrong, or you get the way you're hewing in the Howey test wrong, first of all, it calamitous effects for the rest of the marketplace.
Yeah.
And then second of all, everyone is going to try and get into that loophole. This always happens where people say, it's a tiny market. If we do a little bit of deregulation, it's not going to be a big deal. But when you have deregulation, water flows, and everything is going to take that path to get access to the less regulated market. And again, going to be disastrous. And beyond just the securities markets, but the faith in our markets in general. And whether or not you agree that we should be the financial center of the world, and I certainly think that too much of our economy is finance. It's probably not healthy. But losing that status has a lot of consequences.
Yeah, and I'm glad you brought up that we talked about this with Sean when he was on a couple weeks ago, but the crypto industry was using legislation as kind of a way just to avoid being regulated, period. Don't regulate us yet, pass this bill, but don't pass that bill yet. We got to get the definitions right. And don't focus too long on those definitions. There's bigger things going along. The SEC missed FTX. How are you going to put more things under their control? So it was all meant as kind of a delaying thing. Is it even worth talking about legislation like this, considering the current broader context in which many of these regulators are being very quickly disempowered and they're trying to eliminate broadly their ability to regulate? Is this kind of missing the forest for the trees?
Yeah, I think the other headwind here is that when you're in the House and Senate, you have a limited amount of floor time. You have a constrained amount of time to get all the things you want done. As much as Trump made a big deal about crypto, I don't think that's a high priority for them. And so even if it's a high priority in the individual committees, having your leadership sacrifice floor time to getting that done is a high bar. And so that is also going to be a challenge to get something like this done. So I think that's exactly right.
Broadly, white collar crime enforcement and financial regulations are being actively gutted. The CFPB, they're attempting to fully eliminate. They've talked about eliminating the FDIC. They want to cut the budgets and the funding to everything. For the individuals, the constituents, the investors, the consumers, what is the appropriate way to view this and the way to react to this kind of behavior?
Well, the way to view it is to view it as only scary. So that, there's just no way around that. In terms of what you can do, I think narrowly on crypto, if the SEC does actually do regulation, there's always a notice and comment process. And there are two things about that are to some degree powerful that I think not a lot of non-financial actors know. And so the APA is pretty strong. If you don't follow the process, you make your rule vulnerable on just a process foul. And every issue that's raised in a comment letter has to be addressed in a final rulemaking. And when you make someone say something about why, to justify why they're doing it, you have created for them a litigation risk. So it is actually valuable to write in comments about regulation. Personalized email, form emails don't shift Congress at all. Personalized emails actually do. There are legislative correspondents who tally up how many genuine inquiries they got on an issue, and at least on a weekly basis say, here's what people are yelling at us about. Here's what should be at the top of our priority list. Here's what we should be politically concerned about. So it does matter. But again, it needs to be personalized. It doesn't have to be a lot. It could be, just a paragraph. But it's got to be your own words. The other thing, here is you need to support good journalism. And a lot of that is independent journalism. You guys, Protos, Molly White's, ProPublica, there's a lot of good work being out there in the independent journalism space. And then the other thing I would say, and somewhat self-servingly, is there are a lot of good nonprofit organizations that do this work, that collect sort of and represent the broad set of interest from consumers, and fight on these issues and educate on these issues. Obviously, Consumer Federation of America would love if you supported us. There are tons of groups, Americans for Financial Reform, the National Consumer Law Center, the Coalition for Sensible Safeguards. They do this work and, are worthy of your support. They are effective organizations. And then sort of the broader political issues, for one, direct action, showing up in the streets, it matters, it brings attention to issues, and it's kind of the last refuge of protecting democracy. Make them don't give up. Make them fight for every inch of territory.
Yeah.
Cynicism is deadly. You can affect things. It seems slow. It seems ineffectual, but it does matter. And you can slow this process by just being every bit of a barrier you can be. And you're going to get run over, but it's harder. And I think the other thing is there, in addition to consumer advocacy organizations, there are really expert executive overreach and government investigatory nonprofits. One of those is Protect Democracy, who do a lot of amazing work. One of those is POGO, the Project on Government Oversight. They've been around forever. They have a lot of expertise in this space. They bring cases. And it's really worth it to, again, support those kinds of organizations that are out there doing the work.
Totally agree with that. And I hate to do this to our audience, because I'm sure some of them were okay, well, that's the end of the episode now. But I actually want to show you, just push one more question to you, because you and I talked about it, and I actually found it fascinating. And I think a lot of our listeners don't understand this and will find this fascinating as well. So if anyone hasn't shut the podcast off yet, the president of the United States, Elon Musk, is in my personal opinion, the biggest fraud in the history of the world. And I think he's done a great job of getting away with it. He is manipulative, and he's gross, and he knows how to play people against each other and stuff. One of the things we talked about was, I said, one of the things that really bothered me was after that, whatever it was, I don't know if it was the taking it private at 420 or whatever the hell he said. And the SEC said, okay, you have to have a Twitter sitter. Your days of tweeting whatever you want and having no repercussions, those days are over. And then a few months later, he was just tweeting whatever the fuck he wanted again. And I asked you, I was like, why isn't the SEC doing something? Like, every time this man tweets, they should be fining him. Every single, like, this man should have $1 billion bill, like, sent to his door. Like, okay, here's all the illegal tweets you did. You're tweeting 200 times a day. You owe us a lot of money. And you said, here's the problem. We would have to open up an investigation for every single one of those tweets. But my pushback on you again was, so why would you set that rule up then if you can't enforce the rule? So I guess I'm pushing this just because I'm like, there has to be a better way. Like, there has to be a better way, not just for the American public to have faith in regulators effectuating change against people like Elon Musk, but also for you guys, so that you don't have to open an investigation to find this dude every single time that he tweets, you know?
You kind of brought up something in that question that we didn't talk about. It's a little bit lengthy, but I would love to talk about it. But to your first point, with regard to Elon Musk, look, like, they brought the case in the first place, and there is ongoing litigation. But you are spending a lot of resources taking on the richest man in the world. There is a cost to rulemaking. There is a cost to all the other reforms go out in the market. Now, you have to go after that power when they're breaking the securities laws, so it's not a free for all. But on the other hand, it costs you a lot. And the fundamental unsatisfying part of that case is a bigger problem than the SEC. It's a problem of democracy, where, like, the richest man in the world has a lot of resources, has a lot of political influence. How did we get here in the first place? Like, that's not an SEC like, not to dodge, but like, that fundamental part of rich people get better representation. They can make it a lot harder on you to enforce the law. Like, the SEC is not the only thing he has escaped. Like, that's a bigger problem than disclosure and securities fraud. You also mentioned, like, sort of the idea of faith in these regulatory bodies.
Yeah.
So the first thing I would say is that, to the extent I'm sympathetic with the crypto markets, our traditional markets and market regulators have not clothed themselves in glory. There's a lot of genuine unfairness, injustice, problems with that marketplace. So it's not entirely unreasonable for me to see investors saying, like, well, that system doesn't work. There's some people getting rich over here. Like, I might as well try my luck in this other place. It's not a completely unreasonable position. Now, that doesn't excuse the people making the money, and it doesn't excuse the fraud, and it doesn't excuse all the like, activity that's going on in that space. But it is understandable how this other thing developed. And a lot of that comes from the 2008 crisis, and just the abject failure to demonstrate the way that institutions are supposed to work for regular working Americans. We bailed out the largest institutions, and then a foreclosure crisis raged on, not just to 2010, not just to 2013, through 2016. People were losing their homes, having the very basics of their lives upset, having to move their kids to new schools, having to leave their pets behind. Like, there is correct, righteous anger against institutions that did not show up for these people. And I would blame a lot of the current political position we're in on, like, look, the Tea Party has existed much prior to the crisis, but being able to say to a lot of people, like, look, you're getting taxed, we pay all the stuff, and we have to bail out the banks. That's fundamentally unfair. Is a very good recruiting tool in the face of a political and leadership vacuum from, people with progressive economic views. And I think you can draw the line from that straight through to the Trump administration, the first Trump administration, and the legacy that we've, acquired now.
Great answer. Yeah, I appreciate it. Thank you, Corey. Is there anything else you wanted to address?
No, there are two big issues that I think might be worth talking about. One is the claim of regulation by enforcement and not doing any regulations. And a couple of things I would say about that, and sort of the accusation we didn't meet with market participants. We met with everyone who would come in the door. It was a lot of people. The vast majority of them wanted those meetings to be confidential, which is something that we respect. And again, like nothing came from those, but we were genuine about like, come in, if we need to make some small tweaks because you can show us what doesn't work, we'll get you registered. We will do this project. So I think, the idea that, we didn't do enough outreach and we looked kind of bad for doing that, I think that's unfair. Another issue is inherently, how you go to the courts and say the rules already apply and then put out regulations changing those rules at the same time. Okay, judges look very askance at, well, if the rules apply, why are you doing new rules? That doesn't make any sense. Like, that's another challenge. Again, we offered some guidance. We tried to be helpful, but there's a fundamental tension between enforcing the rules that are already in place and, doing something new. And the last thing is there's like criticism about sort of what you might call like Gary's demeanor or bedside manner. And a couple of things about that are this, like, first of all, when there's $1 million or even $100,000 on the line, like being nice to the industry doesn't get you $100,000. It doesn't get you $1 million. Like it just, there's not a good reason to sort of like it. We didn't lose anything by being confrontational with industry. The second thing is, like, to go up against this industry, you have to be like, if you want good regulators, they're going to have to be contentious. They're going to have to be confrontational. Like, that's what it takes to fight a very, very large financial interest. And there's also just sort of like, there's an inherent arrogance, and this is not just true of Gary, but like of me, myself, to say, of the 330 million Americans, like, I'm the one that should say how this $125 trillion market works. Like, to take that on and think that you have the answers, and we need people to do that, but it is like this inherently arrogant place to start from. So like I think the regulation by enforcement arguments were pretty unfair. I think the win record that we had, we to the extent that cases got judgments, which is not entirely within our control. We won a lot. Library, the Terraform cases, Kik Ken tokens, Telegram Gram tokens. Like famously, our folks caught Do Kwon at that the New York crypto gathering, lending, staking as a service, the Wahi issue where they were giving away information before they listed on Coinbase. We won DAO cases, which were unprecedented, piercing that veil of decentralization. NFTs. God,
DAOs are like something I haven't thought about again for so long.
It's going to be an issue. We handily won the Coinbase motion to dismiss. We brought a lot of cases that we unfortunately ran out of the time to see through. Ripple, like I said, big win. I think that was actually genuinely a big win for us. But those exchange cases, the really big ones we wanted to do, they take a lot of time to build. They take a lot of time to see through. And just very unfortunately, we didn't get all the time we wanted. And look, we're not above criticism. But I really do believe like we had a good strategy. You can disagree with it, but I think we had an intelligent strategy that is very defensible. I think we had a lot of wins. And I think, our administration did a really great job on this issue, given the constraints and courts that we were dealing with.
And I think we should note that like the regulation by enforcement criticism is very often coming from people who would have been deeply disappointed in almost any regulation that would have been presented. Best case scenario, they were hoping for exemptions from regulations to be written for them. And so that's an important context for their criticisms they were levying.
The fundamental ask was, let us do this business with the conflicts of interest.
Yeah.
And that kind of points to, because it's an economic argument, it kind of points to like the truth of crypto, which is the inherent economic argument for it is the regulatory arbitrage. And you take away that regulatory arbitrage and all of a sudden, like, there's not something profitable there. And, the other thing, like, I think we talked a little bit about this, about the tensions of what it claims to be versus what it is. And it is now a more centralized and conflict-prone industry than the traditional finance industry, which was like one of the first complaints. There are tons of intermediaries. It was supposed to be peer-to-peer and without intermediaries.
Yeah.
It was supposed to disrupt TradFi, and they banged down the door getting ETPs into the traditional financial system.
Right.
Like they demanded SEC rules for securities while claiming they were not securities. So like you go down this line of what it pretended to be and where it is now, and it's like, look, the fact of the matter is crypto is a machine where fraud and money laundering go in one side and campaign donations come out the other side. And like that's fundamentally the challenge that is before us now. And you know, like it was never going to live up to its claims. It hasn't. Everything that was supposed to be the use case of crypto has turned out to be vaporware. But they're now in a position to sort of fundamentally undermine the securities laws in a way that's going to be really harmful, not just for crypto investors, but for the broader investing public generally.
Well, and you could argue that not just undermining financial regulations, but with the types of candidates crypto money supported, undermining the constitutional Republican democracy at a more foundational level.
Absolutely true. And that's one of the places where, and don't get me wrong, like Sean is a great guy. We talked about this. He's like acknowledged publicly, so much to his credit. And this is not to. It's just like having the audience. I would like to correct the record on one thing. I worked for Sherrod Brown for 5 years. He was as loud and confrontational and challenging to the industry on crypto as anybody else. He essentially risked his seat, and it's not just crypto is why he lost, but it was certainly influential. And there was a suggestion sort of like they would have had an easier time if he had remained the Democratic head of that committee. And I just think like that is absolutely untrue. Just incredible integrity to continue punching those guys, given the threat of, you know, dumping hundreds of $1 million in a state that Trump won like 55-43. So I just want to make sure folks know that like there was almost no one with as much integrity and as much on the line as Sherrod. And that's one of those places where it is truly unfortunate that a progressive lion of the Senate, representing Ohio, by the way, is lost now.
Cas, do you have anything?
Yeah, I mean, I guess the last thing I want to say is that you heard it here first. Cas Coin is safe, like one of the safest investments you could possibly make. Definitely not a security. Everybody should invest immediately. We're golden. So there you go.